Hello, everyone. I'm Haley Hansen, and welcome to the webinar. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, you'll find multiple application icons for your use during our program today. The first is a PDF of the presentation, which is available in the program materials folder. So feel free to click and download on that. Also, there are auto-generated closed captioning available in today's program. So to turn on closed captioning, you need to click the CC button at the bottom right corner of the media console, and that should turn on your closed captioning. If you have issues, feel free to send a question to, and we'll try to help you. This program has been approved for continuing legal education in a variety of states. We showed that on the slide before we started. But for live attendees, you need to make sure you report your hours by clicking on the CEU icon at the bottom of the screen, and you will receive a certificate of attendance, including the course number, and you will also get a copy of the recording that will all be emailed to you tomorrow. Regarding questions, we had a record number of people sign up for our webinar today, which is excellent, but we honestly don't think we're going to be able to get to any of the questions just with the content that we intend to cover today. So we likely will not be taking any questions. We really encourage you to reach out to either your Husch Blackwell team member or your legal counsel as well if you have additional questions. So with that, I'd like to introduce my news anchor. We feel like we're news anchors today. This is Derek Teeter. Derek represents all types of higher education institutions, including research institutions, all the way to private religious institutions. He is a litigator and does all facets of litigation, including depositions, trials, arbitrations, appeals. Derek has faced a variety of different lawsuits regarding student lawsuits, faculty, employment issues, and disputes with contractors as well. He also focuses on regulatory work and has been a leader with regard to Title IX and does a lot of our Title IX training as well. So you may be very familiar with him. So I'd like to welcome Derek as my co-anchor, and I'll turn it over to you, Derek.
So just a few more words before we dive into content. The primary purpose of this webinar is to explain what the Dear Colleague letter is, to help you understand what it says, and to work through some factual scenarios that illustrate how the points of that letter are likely to be applied in practice. We recognize that the Dear Colleague letter is controversial. We recognize that some legal commentators and organizations disagree with its legal reasoning and the application of legal precedent in it, either in whole or in part. And we understand and know that it has raised particular concerns for administrators, faculty, staff, and students who are deeply committed to diversity, equity, and inclusion in higher education. And some parts of that letter are more controversial and debatable than others. As we will discuss, there are legal challenges to the letter that have already been filed, and the courts will ultimately weigh in on many of the issues that we're going to talk about. Whether to comply with the letter in full or in part, and how to do so and how urgently to do so, those are institution-specific decisions that depend on a range of factors, including your attorney's view of what the Supreme Court or courts in your federal judicial circuit are likely to hold, as well as risk tolerance. And we urge all of you to work with your counsel to make those individualized decisions. With that said, I'm going to pass it back to Haley to dive into our slides and to move forward with our content.
All right, so as you all know, since you signed up for the webinar, we're talking about the DCL on race and education. So our first poll question to you today is, has your institution already made changes to its website, its programs, or other materials in response to February 14th's Dear Colleague letter? Yes, no, or we are waiting to receive additional guidance. So if you'd please go ahead and submit your response. We're going to wait until hopefully around 50% of you respond, and then we'll get started. All right, I'll give you just a little bit more. There we go. Okay, we got about 50%. So let me show you the answers. Well, this is it's a good variety of what we thought we would see today with participants. 45% of you saying yes, we've already started to make changes. 22 no, and we have multiple people that are waiting to see and receive additional guidance. So let's go ahead and get started and talk about the timeline. So I think it's really important as we talk about the webinar today that we really level set where we have been and where we are today. And I want to, as Derek kind of gave a little bit of an intro, I also want to give an intro just to say this is rapidly changing. So information that we give to you today at noon our time Central may change by this evening. And so it is important to make sure that you are connected with your legal counsel, that you're getting legal advice, and that we will do our best as Husch Blackwell to make sure we update you when large changes happen. So, all right, so let's talk about the first executive order on the number of executive orders on January 20th, really talking about topics including DE&I, talking about gender identity and anti-Semitism. And then we have a few weeks later, the Dear Colleague letter released on Valentine's Day that had a flurry of questions because it didn't give a lot of information, but the department did say they would release another guidance document, really FAQs, which happened on February 28th. The press release came out on March 1st, but the document itself is dated on February 28th. And so that's really what we're going to focus on today is the Dear Colleague letter and really focus on the FAQs as well. All right, so as we kind of talk about a Dear Colleague letter, there's a lot of you that are on this webinar today. So I just want to take if you will indulge me, just a second to really explain what is the meaning of a Dear Colleague letter. And I want to start from really unpacking where this falls in the hierarchy when we talk about laws. So obviously we have laws that are passed by Congress, that are signed by the president, and those laws then are interpreted by departments of the federal government. And that goes through a process called notice and rulemaking process, which then creates federal regulations. And as most of you know, federal regulations take a long time to put into place. And in fact, it's likely that a federal regulation can take anywhere from 2.5 to 3.5, even longer years in order to actually go into place. And once a federal regulation goes into place, assuming there's no legal challenges, which there's almost always a legal challenge, then it has the force and effect of law. And when those happen, then we have those regulations to interpret the underlying laws and show how the departments are going to implement and really apply the relevant law in those areas. Then we have what's called sub-regulatory guidance. And that's really what we're talking about when we talk about a Dear Colleague letter. It is sub-regulatory guidance. It does not have the force and effect of law. What it does, though, is it advises institutions on how the Department of Education will apply the law. And it does not bind the Department of Education. Since it doesn't have the force and effect of law, they have discretion when deciding how they will enforce it. So it really is sub-regulatory guidance, and it is guidance. It does not have the force of effect of law. It also does not bind courts in determining the law in a particular case. And after the Supreme Court's decision regarding the Chevron doctrine this summer, in which essentially the Chevron doctrine by Loper Bright was eliminated and said there will be no deference given to the interpretation by the departments, we're really going to say that it is not binding, that the courts can have a de novo review on whatever issue is coming before the court regarding a law, a regulation, or even the Dear Colleague letter. So, all right, so can the Dear Colleague letter be wrong? So assuming the legal issues raised in the DCL make their way into the courts, The judges are the final arbiters. They will make the determination as to what the law means, and they may agree or disagree with different provisions and say that they violate different laws or regulations that are already in effect. And so many Department of Education enforcement actions don't make their way to the courts. And so we do look to Dear Colleague letters for information and guidance as to, again, how the department will interpret. But at the end of the day, it's going to be the courts that make those final determinations. Okay. So can the Dear Colleague letters be challenged? And the answer is yes. And in fact, the Dear Colleague letter we're going to talk about today has been challenged already. It's important to understand, and I make this comment when I'm talking to faculty groups or other groups, that anyone can sue anyone for any reason. It doesn't mean that that lawsuit will be able to proceed. So you've got to have standing. You've got to make sure that there's merits of the case, that there's potential harm. All of those things have to happen. And a favorable outcome doesn't necessarily mean that it will go beyond its jurisdiction. Sometimes we've seen nationwide injunctions and sometimes we haven't, especially in the case when we had injunctive relief regarding the Biden administration Title IX regulations. We saw just specific states that were enjoined and other states were not. So that is possible when it comes to challenges. There are 2 current lawsuits, and Derek is really good because he checked last night to make sure that there wasn't any activity, and there was another case that was filed. One was filed by the American Federation of Teachers, so the teachers union in Maryland, and the other was filed yesterday by the ACLU and by the NEA in district court in New Hampshire, both of which are challenging the DCL. Right now, as we sit today, there's no injunctive release. There's no temporary restraining order enjoining the department from moving forward with the DCL. So that's important, but we have these 2 pending lawsuits. So we always need to make sure things can change, and we don't know what's on the horizon. That other lawsuits may be filed and asking for injunctive relief. The 2 areas that these lawsuits are really attacking, number one, are constitutional challenges within the DCL, and specifically they're looking at things like how are teachers potentially inhibited or prevented from teaching their curriculum? Does this DCL interfere with academic freedom when it comes to the curriculum being taught in particular classrooms? And does that interfere, number one, with academic freedom and run afoul of the First Amendment? And then there's also Administrative Procedure Act issues that are being raised, talking about how the Dear Colleague letter, since it is an abrupt shift in interpretation and policy, how the Administrative Procedure Act works, and whether or not that the language is too vague to be interpreted, whether or not there's other challenges to the actual process of putting out the Dear Colleague letter. Okay. So when we kind of focus on the Dear Colleague letter itself, a few things. It articulates the Department of Education's view regarding the use of race, color, national origin in schools, colleges, and universities. It implicates both Title VI and the Equal Protection Clauses, and we'll talk more about that, especially when we talk about the Supreme Court decision in SFFA, and that's what I'll refer to it as. It is the Students for Fair Admission, or SFFA, versus Harvard and the University of North Carolina. And there's a lot in the FAQs and the DCL that really goes into the department's interpretation of that Supreme Court case that was handed down in 2023 and the implications particularly of that case. So we think it's important to just, as we're level setting, at least talk to you a little bit about SFFA, so Students for Fair Admissions. Again, this applied Title VI and the Equal Protection Clause to admissions practices at Harvard and UNC. And what's important to kind of remember, if you're not an attorney on this call, is that Title VI applies to all institutions. The Equal Protection Clause applies to public institutions. But really, when we're talking about the protections that both apply, they say the same thing. So we're saying the same thing. And in the FFA cases, the Supreme Court held that the benefits of diversity cannot justify the use of race as an eligibility criteria when determining admissions. And then there were several rationales and reasoning that we've kind of been, working through over the last few years. And some of those primary points are the use of race, color, national origin is always subject to what we call strict scrutiny. For the lawyers in the room, they'll know what that is, but it is the highest level of scrutiny that a court will undertake. And basically what the court ultimately found was that diversity did not, could not meet the standard of strict scrutiny. And that was a change in pre-FFA cases. And so the court essentially said that diversity was really too vague for meaningful judicial review, and that the racial categories were both under-inclusive and over-inclusive. An example they gave was that 50% of the population could be included in a group labeled Asian, and so that is over-inclusive, and that there's under-inclusive racial groups that were not being identified as you looked at diversity and decisions regarding admissions. And again, remember, these were looking at a specific question as to whether or not race could be used as a factor at these particular schools. And that racial categories inherently rely on racial stereotypes. And you're going to see this really, translate over when we talk about the DCL as well, and racial stereotyping as we kind of move forward and unpack the DCL. Also, that using race in admissions means that somebody's benefiting and somebody is not, or being benefiting, or somebody is being harmed. And so I think that's important as well. And finally, that there's no logical endpoint to the programs when it comes to diversity. And so, going back to Title VI, I think it's really important to understand that SFFA was really talking about admissions. That was what was before the court. That's what there was a lot of time spent on, of whether or not there could be race could be used as a criteria or eligibility category for admissions. And now we have, as we look at what the DCL is, and Derek's going to really talk about that a little bit more, we understand that Title VI, really applies to much more than just admissions. And really, the Department of Education is interpreting the rationale and reasoning from the court's decision in SFFA and applying it to all different areas of the educational process. And I think it's important to just go back to the statutory language that it's no person in the United States shall, on the ground of race, color, national origin, be excluded from, participation in, denied the benefits of, or subject to discrimination under any program or activity receiving federal financial assistance. And if you read this, you'll kind of understand too that this is very similar language that what we always talk about as an example in Title IX. And a lot of people for a long time thought Title IX just applied to athletics, and there was never the word athletics mentioned in a very similar statement under Title IX when it came to sex. And so it's really important to understand when it comes to race, color, national origin, that it's very broad, and that's how the DCL has interpreted it. So let's ask another poll question. So did your institution make changes to its scholarships in light of the 2023 SFFA decision? And Derek, while, I think I've seen a couple comments come in. One of the comments that came in was that the FAQs, they do give some areas or a specific website on the department's website where you can submit complaints if you believe that an institution or a school district is in violation of the guidance being given in the Dear Colleague letter. So that was the first time that we've seen that. I think it's the first bullet point or first paragraph of the frequently asked questions.
Yeah, I mean, in prior DCLs, how to make a complaint was always sort of the last thing in the letter at the very bottom, along with other language that no one read. And now the DCLs are making that prominent, and there's actually a new reporting web page that the department has set up for people to submit DEI complaints. I think one of the commentators just noted that in the chat box. But there's definitely an attempt to invite complaints, shall we say, so that the department can enforce its view. And looks like we have almost 600 responses to the poll, Haley.
So let's go ahead. So 44% of you said yes, you did make changes in light of SFFA regarding scholarships, and particularly a lot of scholarships that had a race as a factor in their scholarship, and it said 46% of you said no. So Derek, with that, I'm going to let you unpack the DCL, the key points a little bit more.
For sure. Thank you, Haley. And so, this poll question is really illustrative of one of the main, perhaps the most significant point in the DCL. And it's to say that the Supreme Court's reasoning in SFFA is not limited to admissions, but applies broadly to all manner of institutional decisions where benefits and burdens might be allocated based on race. And so one of the most obvious sort of areas where institutions allocate benefits is scholarships. And some institutions sort of saw the writing on the wall, if you will, in SFFA, and began to change protected status-based scholarships even before this DCL was issued. And certainly the DCL takes the position that the prohibition on using race applies to scholarships as another type of program that a school operates, another benefit that it confers, just like admissions. So the DCL takes a very broad view of what sorts of programs and activities are affected by SFFA, and takes the broad view that institutions cannot segregate based on race, even if equal, nor can they distribute benefits or burdens based on race, including color and national origin within the broader term of race. So all the benefits, all the burdens, all the administrative supports, housing, these are all things that this DCL says are now subject to the Supreme Court's prohibition on using diversity as a justification to use race as a determinative factor. I think that it's not surprising that the administration went there. This was sort of anticipated that they would take a broad view of SFFA. There were a couple additional points in the DCL that maybe weren't as anticipated. And one was there's a focus on the concept of stigmatization as another form of discrimination. So if you think about sort of classic discrimination, someone is denied a benefit or given a benefit directly because of race, like money or admissions. Stigmatization is focused on things an institution might do or that it might tolerate others doing that have the practical effect of discriminating against someone, causing them to feel responsible, let's say, for racism, or calling them out based on race and making them do things based on race, or training in a way that assigns moral burdens to groups of people based on race. This DCL says that stigmatization, if it's serious enough, can rise to the level of discrimination. It's sort of an analogous concept to sexual harassment, let's say, that unwelcome, stigmatizing conduct can be serious enough to have the practical effect of discriminating against someone. And the DCL and the FAQs take the position that stigmatization is going to be maybe even more likely in a K-12 setting, where your students are in effect there without choice and don't have maybe the experience and the age to be able to engage in those concepts the same way that college or university students are, where they're expected to endure more things that maybe make them uncomfortable. Another key element of the DCL is the idea that you could have a race-neutral program. In other words, it doesn't allocate benefits or burdens based on race directly, but nonetheless, there was a hidden motivation of racial consideration in adopting the program. And this goes beyond the type of analysis that SFFA engaged in, because SFFA dealt with a direct and sort of open use of race as a plus factor in admissions. What the DCL says is you can have these facially neutral programs that might be secretly motivated by a desire to obtain a racial outcome. And the DCL says that that's a violation of Title VI and the 14th Amendment too. That's probably one of the most controversial elements of the DCL, and the one where we anticipate maybe the greatest sort of court challenge. There was actually a case in the Fourth Circuit involving the Fairfax County schools in Virginia right after SFFA came out that dealt with some changes to the admissions protocols for an elite high school. And this argument was made in that case, and the school actually won. I'm not sure that outcome will be the same across the country, and probably at some point in the future, a case like that will make its way back to the Supreme Court. So just to really emphasize this, the DCL at least takes the position that race, color, national origin cannot be used in assigning benefits or burdens in all aspects of institutional operations. And this slide shows examples of that, of course, admissions, but other things like hiring and scholarships and fellowships and how people are paid, the degree of administrative support that certain segments of the campus receive, and then the catch-all, all other aspects of student and campus life, which is really broad, but it does track the language Haley identified in Title VI, at least, that says the prohibition is on all the educational programs and activities of a school. So after the DCL came out, then we had some additional content that came to us about admissions itself. So Haley, if you can go to that slide. Not only did the DCL focus on sort of the application of SFFA outside of admissions, it also took issue, called out, clarified what the department perceives as some attempts to end run SFFA itself in the admissions context. And the DCL warns institutions that they cannot avoid the direct effect of SFFA by using admissions essays or similar documents as a proxy to determine a student's race and then to allocate benefits based upon that determination. And there was some language in SFFA itself that said, in effect, schools don't try to do indirectly what we told you can't do, but we're also not saying that you cannot consider a particular student's experiences, including maybe experiences of discrimination. And what the department has identified, at least, is the practice that some institutions, which they don't name, maybe are using the essays solely to identify race rather than reading the essays to identify maybe personal characteristics or other admirable qualities that a person has developed because of their experience with race. And that's a fine distinction, but it's one that the DCL makes. Okay, and then we got the FAQs, which said a few more things and maybe elaborated a little bit, and some might say even rounded the edges off some of the harsher points of the DCL, maybe. So the FAQs said a few other things. One, they describe this concept that you can't separate students based on race, even if you are separating them and then providing them equal access, because that's a form of separate but equal, and the FAQs cite back to the Brown v. Board of Education precedents from the mid-20th century, saying the mere fact of separating people into groups based on race is itself pernicious and in violation of the law. It also talked about the concept of DEI programs and whether and when those programs are, in the department's view, in violation of Title VI and the Equal Protection Clause. Some people read the DCL to say, in effect, you can't have DEI programs at all anymore. There's another way of reading the DCL to say they were trying to talk about DEI programs that have stigmatizing content. The FAQs sort of take that view. The FAQs say it's not inherently problematic to have training and classes that are focused on diversity or equity or inclusion. However, the content of those courses, if it relies on stereotypes or stigmatizes, could then cause them to be a problem. or the way in which the courses are held could be stigmatizing and could therefore be a problem. And the FAQs say the department's going to look at all the facts and circumstances of a given program before it decides whether or not it's crossed the line into sort of legitimate academic instruction versus illegitimate stigmatizing conduct, which is not great for guidance because it means it depends on the facts and circumstances. And that makes it hard, of course, for you as schools to plan and to minimize risk. The FAQs do give some examples of what it would mean to stigmatize. Examples like separating people based on race and making them go through trainings in racial groups. Content that purports to assign moral or ethical responsibility for racism to people today based upon what race they are today. Forcing people to engage in certain types of activities like confessing privilege in front of others is given an example of the sorts of things that could, considering all the facts and circumstances, be viewed as stigmatizing by this department. A few other things the FAQ said. One is that Title VI is really broad and applies to all the programs and activities of schools, and that includes their procurement of goods and services from vendors. So that implicates the concept of minority or women-owned business sort of contracting preferences, and this letter saying those are prohibited too by Title VI. There's some explanation in the FAQs about how the department will go about evaluating this idea that you could have a race-neutral program that is nonetheless sort of secretly or with a hidden motive intended to achieve some racial outcome. And what the department's saying there is you can have a facially neutral program, and they're going to ask you as a school in the first instance to explain what your non-race-based motive is for having that program. And then they're going to look to see if there's any evidence that would suggest your articulated non-race-based motive is in fact not genuine, and that you have a hidden motivation based on race. And so those could be a lot of sort of circumstantial facts and evidence, but they could include things like if you've had committee meetings and decided that you want to have a program and you've talked openly about how this program will achieve a certain racial balance. And if there's documentation of that, that could be the sort of thing that this department would say would undermine the bona fides of that purported non-race-based articulated rationale, and then be evidence of this hidden motive that would cause the entire program to be suspect. And we'll show you an example that maybe illustrates kind of the type of thing that they could be looking for. And then lastly, the FAQs say at a conceptual level, it's okay for schools to have educational programming and observances tied to things like national holidays or national affinity months. It's not inherently discriminatory to do that, provided that whatever programming you have is not relying upon race-based stereotypes or stigmatizing people. And so again, it sort of drives us to this facts and circumstances sort of scenario, but acknowledging that some types of programming are okay, even if they deal with topics of diversity, equity, and inclusion. Okay, so with that groundwork laid, we thought the best thing to do was just have some factual scenarios that we can sort of talk to you about and grapple with these elements of the DCL. These are not intended to illustrate things that are necessarily good or bad. They're made up, they aren't coming from clients, but I think they're a great way to talk about sort of these different pieces. So Haley, you want to introduce our first?
Yes, and again, I think it's important that we're not, we're giving you our best information as it sits today. There may be other interpretations or other information that comes later on, and you always want to check with your legal counsel. So that's a theme for today. All right, so here's your first example, Derek, or that I'm going to pose to you. So a regional public university has an open admissions policy and strives to recruit as many students as possible. The student's admissions website contains the following statement: the university welcomes all applicants. persons from traditionally underrepresented groups, including racial and ethnic minorities, are welcome and especially encouraged to apply. What do you think about this one under the DCL?
Yeah, so there's a couple of kind of really interesting points baked into this example. I would say in the end, we think it's probably okay, but it's important to understand how you get there. So one of the undercurrents, or maybe not even undercurrents, expressed sort of points in the DCL's reasoning is the department is really concerned with the allocation of benefits or the imposition of burdens based on race, color, or national origin. So this school, though, has an open admissions policy, which means it's going to take basically any student it can get that meets its sort of objective criteria, whether it's GPA or high school rank. It's not a competitive selective admissions process. And it doesn't look in the scenario like any particular student is more likely to be admitted because of race or more likely to be denied, but there is encouragement of all people to apply, including racial and ethnic minorities. So I don't think the encouragement of people to apply rises to the level of allocating benefits or imposing burdens or imposing a negative on non-racial or ethnic minorities. The phrase underrepresented group, the DCL and the FAQs say, in essence, those are sort of like words we're going to be looking for because they may actually be sort of hidden coded language for race, color, national origin. And so if you were to change the scenario and say there's actually an admissions preference for underrepresented groups, then we might have a different outcome. And that could be something this department would likely drill into. What do you mean by underrepresented groups? And are you, as part of that larger sort of definition, incorporating prohibited protected statuses? But this seems to be okay to us, although it could certainly draw some questions and inquiry.
But I think as you're going through the analysis, it's important to understand what you do have on your content of your website and to make an informed decision, just like you were talking about, like, let's do an analysis and see how it's actually applied at our institution, at our regional public school, to make sure that we feel comfortable with what we're doing. And I think that's really helpful and will also, bring people along as to, why we're making particular changes in some areas, potentially, maybe you're not, and why you're not making changes in others, because you feel like that it does meet not only the law, but, the information within the Dear Colleague letter.
For sure.
So let's ask another one, Derek. So here's a private college with a highly competitive admissions requirements for applicants to submit admissions essays describing how they have overcome significant adversity in their life and how that's going to prepare them for success as a college student. And speaking from the mother of a senior, I've edited some of my son's essays regarding this exact question. So while the college does not expressly ask applicants for their race or ethnicity, when an essay reveals that the applicant is a racial or ethnic minority or from a foreign country, the admissions reviewer has a flag in the file to that application. In practice, and we have a little bit typo. The flagged files are admitted at a higher percentage than the non-flagged files. So what do you think about this one?
So this one, I think, is the type of practice the department would say is doing indirectly what SFFA said schools could not do directly. And I think the department's reasoning in the DCL, at least, would say that this violates Title VI. So the department would look at this and say, okay, admissions is competitive, so it's effectively zero sum, which means if some people get a benefit, that necessarily imposes a burden or a negative on the others who don't get it. So it's different than the open admissions for that reason alone, and much more likely to be seen as an allocation of burdens or benefits. And then what's happening in this scenario, and the DCL uses the phrase race qua race or race as race itself. The school in this scenario is determining race or ethnic status from the essay, and then it appears using race or ethnic status by itself to assign a benefit, rather than evaluating the essay to see if that particular individual had an individualized experience or developed certain character traits because of discrimination or some other sort of race-based phenomenon. The Supreme Court said you could consider the individualized attributes a person might have as a result of their lived experience, but the Supreme Court telegraphed you can't just use essays to determine race and then give a plus based on your determination of race. And with the sort of statistical support in this scenario, it appears that that's what's happening. And so, there's some facts here. There would be definitely a fact-based inquiry, but this sort of practice, I think, is a risky one under the DCL's sort of analysis. And I think it would subject a school to significant scrutiny from the department.
So Derek, what if we change the example a little bit and just said that we took out their flagging for racial or ethnic minority status or a foreign country, that they're from a foreign country, and we had just flags for all sorts of things, like the plus factor and admission of someone at the school, or you're a first generation college student. A lot of schools like to use that flag, or you're the child of an employee at the school. Sometimes there's flags for those particular at some of these highly competitive schools. What about that? Do you think that changes things?
So it probably would. The short answer is flags are not the problem. Flags for legally protected statuses are the problem. And there's not a federal law that prohibits giving a preference to an applicant who has a parent who works at the school, for example. Now, to the extent that you were using some race-neutral criteria as a hidden rationale to discriminate, then maybe flagging is a concern. So at least historically, you might have had schools that would use something like legacy, or maybe even something like religion, as a proxy to try to make sure they were getting non-minority affluent students. And if that sort of evidence were there, then maybe using legacy is a problem. But you would have to have that evidence of the indirect motive, or the sort of hidden motive to use it as a means of engaging in race-based discrimination.
All right, let's go on to the next one. So before SFFA, a private college offered special scholarships only available to racial and ethnic minorities. After SFFA, the private college eliminated all such scholarships, but created a new scholarship only for students who graduated from high schools in certain urban areas with high percentages of Latino students. The college never offered urban scholarships before, and does not offer rural scholarships, and does not offer urban scholarships for several cities whose urban schools have a very high percentage of African Americans. An admissions working group tracks the racial identities of the urban scholarship recipients and has documented that 85% are Latino. The school's president was an ardent public critic of SFFA when it came out.
Yeah, so this is an example that sort of shows how the department might look at something that on its face is race neutral, but there may be enough circumstantial evidence to suggest a sort of hidden racial motivation. So it's not inherently race-based to provide scholarships to students who come from urban centers. That doesn't necessarily implicate race. But if this were challenged, the department would look at it, and at least according to the Dear Colleague letter, would say, are there sort of circumstantial evidences that cause us to question whether you really want urban students or whether you're using that to try to get more Latinos? And so the fact that there has never been an urban scholarship before, the fact that there aren't other geographic scholarships like rural students, the fact that the scholarships appear only to be offered to certain urban areas with high Latino, but they're not offering urban scholarships to areas with high African Americans. All of those could be used to say this is not really a legitimate attempt to get urban students. What you're trying to do is recreate a way of obtaining Latino students through the use of this really highly targeted scholarship. And the fact that you're actually tracking the racial identities of the scholarship recipients illustrates that. And then the department did say, look, we're going to look to a school's public statements as one of those circumstantial pieces of evidence. And so if a school has criticized SFFA and said publicly, we're going to do whatever we can to recreate it, then that's more evidence that could be used against the school in challenging a program like this.
All right, next one, Derek. Before SFFA, a public university offered several types of scholarships to various protected statuses. After SFFA, all scholarships have been eliminated. The university offers new scholarships for students from urban schools, rural schools, Title I schools, first generation students. It also allocates more scholarships for students with financial need. The university does not track the race or ethnicity of the scholarship recipients and does not track the overall race or ethnicity of the composition of its student body. The institution's leadership did not take a public opinion or position in opposition to SFFA. What do you think about this one?
Yeah, so this example is intended to show where maybe we do have bona fide changes that we've made, and we're not using these things as a sort of hidden rationale to recreate sort of a racial balance. How do we know that? So yeah, this school did have protected status scholarships, and then SFFA came out. They recognized they couldn't do that anymore, but they still want to have a diverse student body in the sense of diversity by life experience, economic experience. Maybe they have a mission fit that says we want to serve students who've come up through impoverished conditions, bad schools, Title I schools. And so they're doing multiple things, right? They're not just targeting in a hyper-specific way one particular classification that's going to be highly correlated with race. They're doing the rural schools too. They're also allocating more money broadly to students with financial need, irrespective of race. And oh, by the way, they're not tracking the racial composition of the scholarship recipients, although in this scenario, they are looking at the overall composition of the student body. And they don't have the additional sort of circumstantial piece that the school was especially critical publicly of SFFA. So I think you might be able to defend this sort of program and say, no, this is a bona fide race-neutral effort to try to make sure that we don't have a student body that's just comprised of really rich people from the suburbs. This is what we're trying to do, and we really mean it. We're not hiding our motive.
All right, the next one is, I think,
next one's for you. Yeah. So, okay. So this one, we have a business school at a public university, and they receive a gift from a benefactor to fund a fellowship called the Women in Business Fellowship. And this fellowship includes a monetary stipend, special access to successful female alumni who are CEOs, and it has programming, webinars, seminars on skills such as networking and other things that would be useful, try to position the fellows for success. And only female business majors who have completed 2 years of study and have a high GPA are eligible. The school has some other fellowship programs that any student can apply for, but they're different. They're not the same.
Well, clearly this falls under Title IX and doesn't fall under Title VI, but we're talking about it because I think there's a lot of lessons that we learned from Title IX already. So there's been a lot of enforcement from the Office for Civil Rights, and specifically even during the Democratic administrations, the Biden administration most recently, regarding sex-based programs and even scholarships, and that they needed to be eliminated. So a lot of people take the position at the schools that I work with, and I understand it, that well, we got this from a donor, and this is what the donor wants. That doesn't matter. If this is what you're doing at your public institution and you have accepted these donor gifts, then you have to follow the laws. And so we saw a lot of enforcement regarding this prior to the Trump administration taking over, prior to the DCL, and essentially saying you can't have sex-based programs that only benefit the female sex in this area. And there's been quite a few of them that have been developed over the years, especially trying to get women into places that are traditionally have been underrepresented from women, including STEM programs and also business potentially, and even educational programs regarding, becoming superintendents and other administrative positions. So.
Yeah, and so I saw a couple of questions in the chat. Well, what if we're a private school? Does it make a difference? And I think the answer is no, because Title IX, which is the sort of sex-based counterpart to Title VI, applies broadly to privates and publics who receive federal funds. One question people often ask, well, then how is it that we can have women-only colleges? And the answer is there's a specific exception written into Title IX that says Title IX doesn't apply to admissions at private schools. So that allows you to have a women-only or men-only undergraduate private school. And public schools that were women-only, existing as of 1972 when Title IX was adopted, are grandfathered in. But it's just that narrow exception. The rest of their operations still have to be free of discrimination based on sex. Mm-hmm. So this is interesting then. We'll ask you a poll question. My institution received an OCR complaint about sex-specific awards even before SFFA. So if that's true, pick yes. Say no if it's not. And maybe if you don't know, just don't answer this one. But we were aware at least of a pretty high volume of these sorts of cases coming out even before SFFA, which of course just dealt with the race piece. So we'll give you just a moment to answer that and see what sort of response we get from the room.
Yeah, we're running out of time, and which always happens to us, doesn't it? And so we'll kind of just go ahead and
we got
show
about
you the
400
results.
answers.
Yeah,
so
some did.
Yeah, I mean, almost 26% of you. So an appreciable number. This was happening. Even more of it will happen now. I think SFFA, even though it deals with race, sort of heightens the scrutiny of programs like this. So.
All right, next example. On graduation weekend, a public university allows certain groups to host supplemental graduation ceremonies. For example, the Asian American Student Association hosts a reception for graduating Asian American students. The event is invitation only and takes place on campus in the student union. All students are allowed to attend the university's main graduation ceremony at the stadium. So what do you think about this?
Yeah, so race segregated graduation ceremonies is specifically identified in the FAQs as the type of segregation that the department views as violating Title VI. Now, what's interesting about this example is the school itself is not operating the supplemental graduation ceremony. A student organization is, and it's invitation only. So we presume it's not open to the whole student body. There's going to be some interesting, I think, case law developed that really gets at the intersection of the First Amendment and Title VI, because on the one hand, the courts have said student organizations have certain First Amendment rights, including certain rights to associate with people that sort of share the mission of the organization. And so on the one hand, you could see the Asian American Student Association saying, well, we have a right to have this graduation ceremony with our members because we want to focus on that. And from the school's perspective, though, you're allowing your facilities and perhaps an officially recognized group to also exclude people from a ceremony based on national origin or race, depending on how you characterize Asian. And so that could be a potential problem. I think what is clear is that if the school itself was doing this, like a department of the school, the DCL would view this as violating Title VI because the invitation only is limiting it based on race.
All right. So the next one, I think, is for me.
Yeah. So we have all first-year students at a private college are required to participate in a 2-hour seminar focused on diversity, equity, and inclusion. It includes content on America's history of discrimination, current forms of discrimination, current social and economic disparities resulting from discrimination. And then there's also content on avoiding microaggressions and supporting the use of chosen names and pronouns. The training does not target any particular race as being morally or ethically responsible for the discrimination that it talks about. So what do you think of that one?
Well, the DCL did give us some clarification, because I think that about whether or not you could deliver programs or content that had to do with diversity, equity, and inclusion concepts, and what you could talk about in some of your programs or training. And I think at the DCL basically says that it is not inherently wrong to talk about this. It is only how it is applied. So if you are targeting specific groups to say that you're responsible for these actions that have occurred, or that there is some sort of separation between them, or some way in which you are really separating out racial groups, that's where you run afoul. But when you talk about content and you're educating, that does not run afoul of the DCL. Do you have anything you want to add to that?
I think, and that's where it kind of rounded off a perceived really sharp corner. The FAQ said it's not education on these subjects that is the issue. It's the type of education on these subjects, or how you go about delivering it, that creates the problem. So a fine distinction, but one that matters, I think.
All right, next question. Our example: all first-year students at a private college are required to participate in a 2-hour seminar that focuses on diversity, equity, inclusion. The program is delivered in small groups, so here's the difference. And for one segment of the program, the facilitator separates white students into one side of the room and non-white students into the other side of the room. White students are required to express ways in which they have benefited from privilege, and non-white students are in turn asked to express how they have experienced discrimination.
Yeah, so this is an example of the type of educational programming that I think would raise concerns under the Dear Colleague Letter's view, at least. And there's two parts of it, I think, that would implicate the Dear Colleague Letter. One is the separation of the attendees based on race. So white people on this side, non-whites on the other. That's the segregation element. And then the other part is sort of the stereotype element. We're going to presume that all the white students have privilege, and we're going to presume that all the non-white students have experienced discrimination. And the guidance says it's those sorts of separations and the use of stereotypes that can result in a stigmatizing type of program, as compared to the prior one where people are just sitting in an auditorium and presumably sort of receiving content.
All right, next one. We're running out of time. So the mission of the institution's multicultural student office is to support students who are racial and ethnic minorities, international students, LGBTQ+ students. The office provides free tutoring to students who identify as members of the beneficiary groups. If a student who does not identify as a member of the beneficiary groups asks for tutoring, the office refers the student to the University Student Support Center, which has more limited tutoring options available to any student at the institution.
So one of the things the Dear Colleague Letter and the FAQ say is the department will look at a discriminatory allocation of administrative supports for students. And I think tutoring is an example of an administrative support that a school might provide to students. And if tutoring is provided in a way where certain students benefit because of race and other students don't, then that could be a problem under the way the DCL construes Title VI. So I think the issue with this scenario is there appears to be a qualitative difference in the type of tutoring that certain groups of students get access to sort of more readily available tutoring. And if you're not in those groups, you have to go to the default center, which has fewer options. And so the department might view this as the use of race to provide a more significant administrative support to certain students based on race or other protected statuses that would be implicated by Title IX or Title VI. Of course, you could say, well, the reason we need to do that is because these groups maybe have not had as great of education coming up, maybe they are more impoverished, et cetera. And this department would say, you're using stereotypes then because you're presuming things about people. So whether you agree with it or not, I think this scenario does implicate the DCL's view, at least, of Title VI.
Does the analysis change at all, Derek, if it's a public institution versus a private one?
Yeah, so on this one, again, I would say it doesn't, because Title VI applies to all schools that take federal funds, and the Equal Protection Clause applies to publics, but it applies the same way as Title VI. So one way or the other, the department is saying the same legal principles apply.
Okay, just a couple more if you can hang with us. If not, thank you for joining us today, but we'll be done in about 5 minutes. A public university offers majors in Asian studies, African studies, Latin American studies, and the students have now petitioned the university to offer a European studies major, but the institution has declined. The institution also offers special programming on Martin Luther King Day, Holocaust Remembrance Day, and other selected holidays associated with racial and ethnic minority figures or groups. Any student is eligible to enroll in one of the majors or participate in the special programming. What do you think about this one?
Yeah, so this one probably is okay in our view. The FAQs clarify that you can have educational programs that are focused on things like particular holidays or affinity months. And there's a certain deference to legitimate academic freedom. And not every school has a studies major associated with every sort of geographic area of the world. And so provided there are legitimate non-race-based reasons for this, like we only have so many units we can have, we're trying to develop majors that people actually enroll in, and we have lots of holidays and observances, and we can't do them all, but the ones we do, anybody can participate in, then the FAQ suggests that that's fine and not problematic. Again, provided you're not making people do things that are stigmatizing and you're not employing stereotypes, which is always the caveat in these documents.
Okay, last one.
Okay, so this is for Haley. A public university procures a range of goods and services from local and regional vendors, and the university adopts a program that awards certain preferences to vendors that are at least 50% owned by women or racial or ethnic minorities. And the institution tracks the number of women and minority-owned businesses that receive its awards, and even sets internal quotas for how many of such awards they want to pass out. So what do you think about that one?
This is squarely falls in, at least within the guidance of what the DCL is not allowed under, would violate Title VI. And so this would be something that this public university would need to look at and determine if they wanted to move forward. But at least with the department's interpretation, this practice violates Title VI of setting aside these preferences. So, all right. So we've given you a lot of information. Hopefully it's been helpful to you. I think what we want to kind of just end with is, where do you go from here? You understand the law. We've given you some examples that we've walked through. You've written lots of questions about your specific institutions. And I think those questions are very helpful because it just illustrates the point that we're trying to make. Number one, you need to reach out to your legal counsel and make sure that they're helping you as you analyze what's going on at your institution so that you have the right analysis. So legal counsel is really important. The second, I really recommend that you do some sort of an assessment of what you think the problematic programs or groups or preferences in this scenario or other things may be, and really try to get a handle on how are we going to approach these issues of whether or not we're going to make changes and what we analyze our risk to be. And in doing that, you want to have your legal counsel so you can have some attorney-client privilege involved in that as well. And as you look at that, a lot of our schools are using tools like AI, and they're using keywords like diversity, equity, and inclusion, and finding out, sometimes we have schools that have very decentralized education models, and so they may not be aware of all the things that are going on at different areas of an institution. And so it gives you a handle, even more than, I guess, the administrative team, on what's actually happening at your school. And then you need to go through an assessment and really make decisions as to where you are okay with some level of risk, where you think you need to make changes and be on board with your team as you're trying to navigate these challenges. If you try to do it in a silo, it's not going to help. It's not going to work very well. So making sure that people understand, because a lot of this is, as Derek said at the beginning, highly controversial. It's upsetting to a lot of people, and you've got to make sure that you have a plan of action that really looks at what's happening at your institution. Anything else you want to add, Derek?
Yeah, I guess just in closing to say that we hope the webinar has been helpful to you in understanding at least what the DCL says. And we understand that schools are going to make different decisions about how and to what extent they're going to comply with the DCL now or later. Some of you that are risk averse may comply with it entirely. Others of you may say, we think parts of it are wrong. And our attorney is going to advise us to hold back and not make these changes. And those decisions are going to vary across the industry and vary by school and vary by what circuit you're in. And that's why we're urging you to have these individual discussions with your teams, with your lawyers, understand what you have, and then make these individualized decisions about how you're going to proceed.
Thanks. That's awesome. Great. Yeah. Well, I think we can close up the webinar then.
Yeah. So thank you all for joining us. Of course, we appreciate your comments. You will receive an email in a few days or maybe a few hours probably with the opportunity to give us that feedback and also the follow-up on CLE credits. And you'll also receive a link to view the webinar. So thank you all for your time today. We appreciate you joining us.
Thank you very much.